she's afraid. So I don't know how that plays out, but we've been going through this trial, and it's just outstanding, and I just figured we ought to clear it up.
Yep. I don't agree with Mr. Cable's statement of this. I mean, that motion was in terms of their expert, in terms of the potential jury instructions. It's just a perfunctory motion in terms of, we believe the law says that they're not allowed to address the intent at all, but the court overruled those objections. So.
Yep. I think it's moot.
Right. That I didn't pick up that that's what it was intended for, and that's my fault. So.
Okay.
I agree.
Anything we need to put on?
Not from the defense, Your Honor, no.
All right, let's go get it. Hearing. No, she doesn't, as she walks by. Does Courtney have the jury instructions?
From the chair, Your Honor.
Oh, okay.
All rise.
Have a seat. Everyone have a good evening last night? Perfect. Is there any closing argument on behalf of the defense?
Yes, Your Honor. May I proceed?
You may.
Thank you very much. May it please the court, Carla, Ms. Stevens, Andy, Mr. Cable, Ms. Pritchard. Good morning, ladies and gentlemen of the jury. First and foremost, I want to thank you. I want to thank you because you stood up in the beginning of this trial and you took an oath. You took an oath to keep an open mind and not form any opinions or conclusions and be fair and impartial until you heard the entire case, all the opening statements, the evidence, and the closing statements. Now, Ms. Stevens and I have been a bit busy, but we've tried to watch you, and I do believe you kept that oath. And I know it was hard last night after you only heard part of the closing to not form any opinions. And we thank you for keeping that oath. And I know everyone in the courtroom thanks you, because without you keeping your oath and doing your civic duty, we wouldn't have the best criminal justice system in the world. So thank you very much, ladies and gentlemen. Closings. A chance for each side to lead you down what they believe the evidence will show, not show, what the government didn't prove, what we did prove. It's a time to argue. Now, throughout the trial, ladies and gentlemen, and right before the trial, I try to think of what's a concise, simple way to keep it simple of some complex concepts here. And I had a pretty good framework. And I had a pretty good framework to tell you about until yesterday happened, okay? So it kind of went out the window yesterday. So because of timing and because of other stuff. So what I have to do, ladies and gentlemen, is I have to start with what occurred yesterday. I have to address, first of all, clear up some misleadings that you were placed in, to clear up some issues with regards to the law and the concepts that I didn't get a chance to immediately yesterday because of the timing. And what I mean, ladies and gentlemen, is the state, through Ms. Pritchard, wants you to analyze and try to attack Andy Mitchell's credibility and whether he was a reasonable officer or not with topics. And they're topics and words that don't exist. You won't find them in those jury instructions, but yet they continue to use those. What do I mean by that? The first one, they're made up concepts, ladies and gentlemen. They're made up concepts. The first one, ladies and gentlemen, nowhere will you see in there a term called safety practices. She put up on her thing, safety practices, okay? You won't find those. That's a made-up word by Miss Pritchard. You won't find those in your jury instructions. They're up on her PowerPoint, but they don't exist. And guess what? They're not relevant to this case. So they create words and concepts to lead you astray. Let me give you an example. In this situation, ladies and gentlemen, they made up a concept. They came up with a new standard that you want to review, Mr. Mitchell's reasonableness and his credibility. That's something that doesn't exist, the standard. And what did they say? They're asking, they cross-examined him and they argued in closing arguments for not doing something he's not required to do. Let me say that again. They gave you false premises of not doing something that he's not required to do. First example, okay? Or let me give you an example in life to illustrate what I mean, okay? You're driving, you own a motorcycle. It's a beautiful day, okay? You're out there with a motorcycle, hairs are going in the wind, you're abiding all the laws. You get pulled over. The officer comes and pulls you over. You said, I wasn't speeding. What are you doing? Well, I pulled you over because you didn't have a helmet on. And you say, hey, you don't have to have a helmet in the state of Ohio. And the officer goes, you know what? I know, but I'm citing you because it's a safety tactic. They're going after credibility of something you're not required to do. You're not required to wear a helmet in the state of Ohio. So you can't be cited for it, and your credibility doesn't get attacked, or your reasonableness doesn't get attacked. And that's the false premise that they put forward yesterday in their closings. The biggest hypocrisy of that, ladies and gentlemen, again, you will not see the word safety tactics in your jury instructions. You'll see the Graham factors, you'll see the White factors, you won't see any of that. The biggest example that they did that's ridiculous, ladies and gentlemen, is Miss Pritchard in closing argument said he could have called 911. He could have called 911. Let's see how that plays out. I'm the 911 operator. I get a call. 911, what's your emergency? Geez, this is Andy Mitchell. I'm in a car and I got someone who's resisting. Can you send out 911? Wait a minute, Mr. Mitchell, you're a police officer? Yeah. How ridiculous is that? They cross-examined him on that. I asked him, Andy, in the hundreds of arrests that people resisted, have you ever called 911? No, they're not trained to do that. But yet, they give you a false premise, a false narrative. How on earth that he didn't call 911, therefore he's not credible and he's not reasonable? It doesn't enter his mind, ladies and gentlemen, because they're not trained to call 911. They are the 911. But Ms. Pritchard puts forward that false premise and that concept. They're asking you to analyze something that they're not required to do. You can't go after someone's credibility or reasonableness if you're not required to do it. Next example, the badge. There is no requirement whatsoever, ladies and gentlemen, in the Columbus Division of Police in 2000, in that time frame, that you are required to have your badge when you're undercover. So again, nothing in there you will see in your jury instructions about that. There's no requirement. There is no requirement, ladies and gentlemen, that you have to have your walkie when you're undercover. No requirement. Again, they're asking to judge his credibility and reasonableness on something he's not required to do. It's preposterous. There is no requirement, ladies and gentlemen, that he has to have a second person present with him at an arrest. Zero. None. So Ms. Pritchard cross-examined him with a directive that says you have to have another officer present. That's how desperate they are in their case, that they want you to focus on the word present. Okay, so what did we do with Sergeant Evans? Sergeant Evans, what does the directive that she says in terms of having someone present? He goes, that's close proximity. What's close proximity? The same precinct. What do you mean by that? Well, you can't have two officers, one in the south side of Columbus working and one in the north side of Columbus. That's what the directive's for. So again, there is no requirement that he has to have someone else right next to him. Because Why? You can't arrest people for prostitution if you have two people in the car. Okay? In the area, the proximity. There was a team out there that day, ladies and gentlemen. But because he didn't wait to arrest her until someone was right next to him, therefore you should judge his reasonableness and credibility. It doesn't work like that. You can't be required to do something that you're not required to do, but then be judged on it. Nothing says that you can't arrest someone by yourself. Each and every law enforcement officer that they put up, the first three, McDaniel, Evans, and Shepard, all said, yeah, you can arrest someone by yourself, especially in the vice unit. It happens all the time. Ladies and gentlemen, there is no requirement that you take someone to the library. There's no requirement. It's a false premise. There's no requirement that you take them to the Princeton Club when you have them. Why, ladies and gentlemen? Use your common sense. Well, because of the cop test. When someone who's engaging in solicitation and prostitution, they're touching, they're feeling it, they're seeing whether or not a cop test. You have to use your own discretion, which they're allowed to do, whether or not to take them to the library, or whether or not to take them to the Princeton Club, or take them to an area who's directing. False premise. She goes, you can't hear if she's directing him. You'll hear in the tape recording, ladies and gentlemen, that Andy Mitchell says, hey, what streets are we at? And she tells him. How can he direct himself there if he doesn't know that area? It's preposterous, ladies and gentlemen, but that's how they go after his reasonableness and his credibility. Their own expert, ladies and gentlemen, said the best arrests are sometimes when you are unannounced and you're not in uniform. And that's lawful. That's lawful. But yet they want to attack his credibility and his reasonableness. Just like you're not required to have a helmet on when you ride a motorcycle, you're not required to do those things. Now, as a parent, hey, do I want my kid wearing a helmet? Probably yeah. But when they're 18 or 20, they get to decide. It's their decision. There's no requirement, ladies and gentlemen. There is absolutely no requirements whatsoever to give verbal commands in a deadly force incident. None. Both experts said that. And why? Because they're, and I quote, notoriously ineffective. There is no requirement to de-escalate once you've been a victim of deadly force. But they want to dance around that. The de-escalation, ladies and gentlemen, comes when you're trying to handcuff them. It comes with showing them, hey, yeah, here's my ID. Here's all the things. That's a de-escalation. Once there's deadly force used on an officer, there is absolutely no requirement to shout commands, to submit or anything like that, because they don't have time and they're not trained to do that. This case is unique because it's training, ladies and gentlemen. That's what everyone talks about, the training. And there's no requirement to de-escalate or give verbal commands once the attack is on. Ladies and gentlemen, there's no requirement to text the group. Miss Pritchard said, oh yeah, up there, he didn't let him know that I got one, or I'm talking about one. And how hypocritical, because their own evidence, their own text chain that they put in, look at it. On there, it says, Andy's on there and the team's on there. I walked them through it. And it says, Andy says, anybody out there? Lord Evans says, yeah, McKissick's got one at the library. Did McKissick say in advance, hey, I'm looking at one. Hey, I'm on the way to do this one. No, because it's not a requirement. But yet it's okay for McKissick to do it, but in their eyes, it's not okay for Andy to do that. And he told you he didn't have time. Did he afterwards say, hey, I'm going to text my buddies? Hey, where are we at? Tells them stuff like that? Of course. But somehow, because he didn't say before she got in the car, hey, I think I've got one. There's no requirement, ladies and gentlemen. There is absolutely no requirement that you give your ID number when you give an arrest. Andy Mitchell, you're under arrest. My badge number is this, this, and this. How preposterous is that? I asked that to Sergeant Evans, who's worked the streets, who's a supervisor of vice, who's been in the internal affairs. He's never investigated that. He's never disciplined anybody that. And he said, no, I've never done that. What did he tell you, though? He told you the only time you're required to give your badge ID number is if a citizen has a complaint and they say, I want your name and badge ID number. You have to give it. That's requirement. Sergeant Evans knows the policies. He knows the things. Each officer that testified agreed with what occurs in these types of scenarios, in those types of neighborhoods with prostitution and things like that. That's what they're trained to do. And to allow the prosecution, ladies and gentlemen, to give a false narrative is unacceptable. Ladies and gentlemen, those things have zero to do with whether or not my client used deadly force. Zero to do with whether or not he's allowed to. Nothing. It's a distraction and a red herring. It's a false premise. What's the other false premises that you heard yesterday by Ms. Pritchard? She cross-examined our expert on a book about private citizen defense. 19 minutes of cross-examination on a book about private citizen defense. This is not a private citizen case. None of those topics have anything to do with a police officer on the job with a lawful arrest, receiving a knife cut, receiving choking, and whether or not they're allowed to use deadly force. That's the issue. Are you allowed to go from non-deadly to deadly force or lethal force? Okay? And whether or not there's terms in a book about what citizens do has nothing to do with this case. Why? It's a false premise. Second one, terms. Remember she used the terms, well, Mr. Davis, don't in your book about investigations you say you should take cover and you should hunker down? He looks at her and says, well, yeah. What book? She shows him, well, that book, ma'am, is about someone, a citizen at home who's a victim of a burglary, whether they should go out and investigate or whether they should stay in and take cover and hunker down. This is not a case about a burglary. This has nothing to do with a citizen being a burglary, but yet that's their premise. Because they have no other case, ladies and gentlemen, because their theory of the case doesn't match the law and it doesn't match the facts. A false narrative. The door being open. Ladies and gentlemen, if you don't know something's open, you can't take that into consideration of what the person believed at the time. The law states you must look at what he believed. He believed that the door was closed. So how on earth can he take steps to take cover and stuff like that? Tactics are not allowed in the analysis of reasonableness. They're not. Both experts told you that. Whose belief matters? Mr. Mitchell's. Whose perceptions matter? Mr. Mitchell's. At any time, did anybody answer from that stand, you know what, Mr. Mitchell's perceptions matter and beliefs, but so do Ms. Castleberry's? No. Nobody told you that, and it's not in the jury instructions. It's not in the law. But they don't have a case, so they have to somehow give you these false narratives. The biggest one, ladies and gentlemen, that happened right towards the end of the prosecutor's closing is Donna Castleberry, she tells you and puts it up on the screen, didn't say to Andy Mitchell, I'm going to kill you. All right, I guess so now the prosecution's theory and the standard in use of deadly force cases is that in order for someone to use deadly force, based on their premise, they would have to say, I'm going to kill you. You won't find that in there. Words don't kill people, ladies and gentlemen. Knives kill people. Choking kills people. Words don't. The preposterous thing to give you an argument that well, Donna Castleberry didn't say she was going to kill him. They're not trained on that, ladies and gentlemen. Now, it won't. The things I just talked about, you will find none of them in the jury instructions because they don't matter. So let's turn gears a little bit. Let's switch gears and let's talk about stuff that matters. Analysis that you have to do of what actually the law is and the factors that you're supposed to look at, okay? So in terms of a brief statement of the concepts, real brief statement, and the jury instructions kind of outline that. First, you have to analyze whether or not the state proved each and every element, including the mental elements, beyond a reasonable doubt. Proof of such nature, you would rely upon it in the most important of your own affairs. Surgery for a child, care for an elderly parent. Not more likely than not, smidge over 50%, not clear and convincing, I'm pretty firmly convinced of this, proof beyond a reasonable doubt, okay? Every element, including the mental elements. Then, and only then, if you find that they didn't meet their burden, ladies and gentlemen, you stop. It's not guilty of both. If you have found, respectfully, that they met their burden, then your analysis goes, did we meet our burden? What's our burden? More likely than not, a little bit more than 50%. More likely than not, 2 components. First, whether or not Andy Mitchell had a subjective belief that he was in fear of imminent or serious harm or death. Imminent meaning soon to come. Okay, that's the first prong we would have to prove, more likely than not. Now, in that situation, ladies and gentlemen, and only in that situation, the law will tell you, you are to look at his intent. His intent. That's why it says subjectively, and we talked about that in voir dire. Next, if we prove that more likely than not, then your analysis goes to, based on that, okay, was it reasonable, okay, was it more likely than not that he was allowed to use deadly force at that point in time based on the totality of the situation and based on a reasonable officer, not the prosecution, but based on a reasonable officer in those shoes experiencing and undergoing everything involved in that life and death struggle, everything involved in that resisting. Would it be reasonable to think that and believe it? It's not should have, it's not could have, it's not didn't you have the chance to do this. That's not the analysis on our case, ladies and gentlemen, and don't let them conflate that. All right, more likely than not, those 2 prongs. All right. Now, what happens, ladies and gentlemen, if you find that they meet their burden? Well, if we meet our burden, it's over as well. Not guilty on both counts. More likely than not. What happens if you find they met their burden and we met our burden? Their burden's up here, our burden's down here, but ladies and gentlemen, our burden trumps them. Even if you find that they met their burden, if you find that we met ours, it has to be not guilty. Okay? And that's what we talked about in voir dire with the process. Now, I want to start with why the state didn't meet their burden. Remember, first analysis, whether or not they met their burden on the murder charge and the manslaughter charge. So I'm going to start with that analysis, okay? You with me? So on those concepts, all right? So first and foremost, they've given you 2 competing theories, ladies and gentlemen. They don't even believe in their own case. They've given you 2 competing theories. What do I mean by that? Theory number 1 in the murder case, that my client formed the intent to seriously injure someone with a deadly weapon. Okay? Not to kill them, but to seriously injure. And then they died as a result of that. So that's their charge number 1. That's the murder. It's called felony murder. During the commission of a felony, in this case, felonious assault, somebody dies. So the intent there is my client's intending to commit a felonious assault. Now, the second one they give you is manslaughter. Not intent to harm or kill, but Andy Mitchell was such in a fit of rage, and sudden fit of rage, of high intensity and great nature, that he said, I'm going to kill that person. So he tried to kill that person, okay? So one of their theories is try to injure the person. That competes with trying to kill the person. That's why Ms. Pritchard told you in closing, you can't find him guilty of both. So they don't even believe in their case. They throw it up on a board, 2 competing theories. Guess what else it competes with? It competes with their own evidence. Guess what else? How? With Yuri Patrick. What did Yuri Patrick talk to you about mental elements? Yuri Patrick testified they are not trained to injure or wound someone. Remember I said injury? He goes, well, they get a wound. Are they trained to wound someone? He said no. I said, are they trained to kill someone? He said no. They don't formulate the intent to kill somebody. They don't formulate the intent to wound somebody or injure somebody. They shoot till the threat is incapacitated. That's what they're trained to do. Ladies and gentlemen, you might not like that concept or not, but this is not a citizen case. If Mr. Mitchell was not on duty, there's different situations. He was on duty and performing a legal function. He had a lawful arrest. So now their own expert tells you that in fact, they don't form the intent. Those were his words. They don't form the intent to injure or harm. They don't form the intent to kill. So not only do their theories compete, ladies and gentlemen, their expert disintegrates that. It goes out the window just like when Donna Castleberry threw the handcuffs out the window. That's what that is. That's why they can't prove their case beyond a reasonable doubt, the first reason, because of the mental elements. I want to look at manslaughter, okay? The instructions are in there. Please rely upon them. The judge already read them to you. They have to prove beyond a reasonable doubt manslaughter, okay? And that concept, ladies and gentlemen, is one of provocation. A sudden fit of rage. Because of something that Donna Castleberry did, it caused my client to have a sudden fit of rage. It has to be sudden, ladies and gentlemen. It has to be a large amount, you'll read in the jury instructions. My client didn't fire his weapon, ladies and gentlemen. Donna Castleberry resisted. My client didn't file his weapon, ladies and gentlemen, when he said, fuck you. Okay? Now, we would submit that that's not even close to any proof of sudden fit of rage or passion, but he didn't. 47 seconds goes by. So their theory of the case is he was provoked so suddenly by something she did that yes, you can find there's a sudden fit of rage. Ladies and gentlemen. So obviously their theory is, well, geez, it's either the cutting, the attempted murder or felonious assault of him, or the choking that caused him to be provoked. But ladies and gentlemen, again, enter Mr. Patrick. Their own expert says that situation, cutting, is not provocation. Cutting can't be provocation. Why? Because Mr. Patrick and Mr. Davis both said, hey, if Andy would have seen the knife beforehand, he'd be justified in shooting. But he didn't. Their own expert, as well as ours, said if Andy Mitchell saw them after he was slashed with 34 stitches and a blood transfusion and surgery, if after that, right after that, their own expert said he'd be justified in using deadly force. So if the own expert says he's justified both before the cut and after the cut, how on earth could that be provocation? It can't be. You can't be justified before and after the cut, but yet provocation be that. They can't come close to meeting their burden on proof beyond a reasonable doubt, ladies and gentlemen, of manslaughter. You can't have a legal expert say that they're justified right before the knife and right after, but yet claim provocation, okay? Now, again, their own expert, they are not trained to shoot to kill or shoot to wound. They don't form that intent. It's real simple, ladies and gentlemen. They don't. Now, let's examine provocation. Provocation's a bit different in the jury instructions. They have to prove manslaughter beyond a reasonable doubt, but provocation only has to be proved more likely than not, okay? And it can come from anywhere. We didn't give you any proof of provocation. So what proof of provocation is there more likely than not? What proof of that? A sudden fit of rage of an intense amount. More likely than not was he provoked in a sudden fit of rage, okay? Well, let's look at it. Fuck you. 47 seconds later. Every day in our lives, street language, stuff like that, ladies and gentlemen, the fuck you, I'm going to cuff you. He didn't say fuck you, I'm going to shoot you, okay? And there is nothing in the regulations, ladies and gentlemen, that says you can't use the F word. Again, she asked, well, Mr. Mitchell, you used profanity in there. Yeah. Was he mad? I asked him. No. They asked him, weren't you mad? No. I was frustrated that she was resisting arrest and didn't believe I was a police officer after showing her my ID, after showing her the paperwork, after showing her the handcuffs, after showing her the affidavit. And then most importantly, you heard it on there. After all that, he said, do you still don't believe I'm a police officer? And what she said, nah, I'm not saying that. Nah, I didn't say that. So their theory of the case, ladies and gentlemen, contradicts itself on provocation. And again, somebody has to prove it more likely than not. There has to be evidence more likely than not of provocation. Their own case, ladies and gentlemen, the cadence, okay? The cadence, the shot cadence, has been a big issue in this case, right? Now let's apply it to the concept of provocation, all right? In the murder case, what are they arguing? What's their experts say? The cadence was too slow. 11 seconds, 12 seconds, 14 seconds, whatever it is. The cadence was too slow, right? What does that compete with? The provocation. If the cadence is too slow, it can't be sudden. It can't be a sudden fit of rage. Okay? So on one side of their mouth, they're talking about the cadence is too slow because it took 11 seconds. These officers fire in training with 5 bullets in 1 second. The cadence is too slow. But that competes with the sudden nature of a provocation. Sudden. Their own theories of the shot cadence contradict those charges. Ladies and gentlemen, if you have a doubt of whether or not it's too slow or too quick, that's a reasonable doubt with regards to manslaughter. That's a reasonable doubt. If you have two equal inferences about a concept of murder and a concept of manslaughter, if you find yourself hypothetically back there saying, well, geez, is this shot too slow for murder but too not quick enough for sudden fit of rage? That in and of itself is not proof you rely upon the most important of your own affairs. You wouldn't. In and of itself, their own case contradicts, ladies and gentlemen. Murder, Cade, not fast enough. Provocation, it's too slow. One negates the other, ladies and gentlemen. And the only time you go forward with two inconsistent theories, ladies and gentlemen, and two inconsistent things with cadence and provocation is when you don't have enough for one charge, ladies and gentlemen. That's the only time you do that. You don't have enough to prove on one charge, so you throw it all up there and you give competing theories. You throw it on the board and see what sticks. So ladies and gentlemen, first and foremost, we've shown you one way that they have not proven their burden beyond a reasonable doubt. The second way they haven't, ladies and gentlemen, and it happens because they start with a premise and they work backwards. What do I mean by that? They indict a case in 2019. That's your case number, okay? They don't hire an expert and get an expert till June of 2020, okay? The charge is already there. So they bring in an expert. The train's left the station, ladies and gentlemen. The prosecution's decided to charge somebody. Probable cause, the lowest level needed to charge somebody, okay? So they start from a premise and they work backwards. And how do you know they work backwards? How do you know, ladies and gentlemen? And this is the disturbing part of the case. How do you know? Annie Mitchell gave a written statement. Gave a written statement. Tried to recollect the best he could based on a life and death situation. Gave a written statement. Gives it to Detective Shepard. Detective Shepard reads it. First time anybody knows what Annie Mitchell believed happened. Detective Shepard says, hey, geez, there's an allegation that he got choked with her foot. Geez, I got some sandals. Maybe I should test these. He goes to the prosecutor's team and he says, should I test this DNA on the sand, see if there's any DNA on the sandals? And the team tells him no. Because they start from a premise. They don't want to know the results. They don't want them. They want to hide that from you. Thank God. Think of the injustice that occurred if Detective Shepard didn't do his job thoroughly. Didn't go ahead and do that anyway. Most detectives, when the prosecutors tell them something, don't do that, they don't do it. They have the audacity to say, don't test it. They don't want those results. They don't want there to be any corroboration potentially for Annie Mitchell's statement. Ms. Pritchard and Mr. Cable went at lengths to try to use their words and questions when they analyzed the video up there, what their perceptions of what the video shows and things of that nature, right? Isn't the person here? Isn't the person there? But ladies and gentlemen, they have an expert, Mr. Loomis. He is trained every day of his life to look at video, listen to audio, and try to determine. He's trained, ladies and gentlemen. And I asked him, what an honest person. I said, can you see any more? What does it mean to enlarge something? They use the word clarify. Does that clarify? When I ask, hey, when you enlarge something, does it clarify? He goes, no, it just makes it bigger so you can see a bigger portion of it on the screen. And I asked him, could you see any detailed movements in there? He says no, because he doesn't have a perspective. He's not starting from a premise, ladies and gentlemen. He's just looking at it objectively. If Mr. Loomis, who works on these types of things every day of his life and is trained to do that for BCI, thought you could see detailed movements, he'd tell you. But they want you to listen to their beliefs of what the video shows and doesn't show. Both experts says, you can't see what happens in the back seat. You can't see those things, okay? What did they hide from you with regards to their case? And again, imagine if he didn't test that sandal, ladies and gentlemen. Did you hear anything about the choking in the government's opening statement? No. Did you hear anything about the choking when the government did direct examination on Uri Patrick? No. Did you hear anything about DNA in their case with Mr. Patrick or no? No. Because they don't want you to know that. Did he put that concept and the description of the choking in his report, Mr. Patrick? No. Because they start from a premise and they work backwards. when I asked him, I said, well, you didn't put the choking, detailed the choking in your report. And he says, and I quote, "You can't take Mitchell for his word." Okay. So it's a good thing that Detective Shepard did it. I said, what about, isn't there corroboration on that? He gave me that blank look. I said, corroboration with the DNA. And did you see his face and his head? He just put it down. Because then he knows, ladies and gentlemen. He just told you that there was no corroboration and you can't take Andy Mitchell on his word. And I said, but there is corroboration. And he goes, yes. So then when we talk about it, I asked him specifically, so is that consistent with someone being choked? He didn't even say consistent, ladies and gentlemen. He said, and I quote, "It is indicative that the choking happened." Okay, so he has to be honest on that. Does he put it in the report? No. But then when you're shown, is that corroboration? Yes. Okay, Andy Mitchell must be the luckiest son of a bitch in the world that he makes up a lie about choking, and somehow there's Donna Castleberry's DNA on the bottom, or his DNA on the bottom of Donna Castleberry's thing. Whew. Got away with that lie. Wow. Imagine what they would tell you, ladies and gentlemen, if there was no corroboration with the DNA. Imagine what that first closing argument would have been like. Go through the pictures. Miss Pritchard talks about it could have got it from kicking him in the leg or something like that. He has jeans on. He has a shirt on. He has a full stuff on. Look for the open areas to determine whether or not Mr. Mitchell's consistent or credible. The neck's wide open. There's some spaces on the things, okay? But they've got to give you those false narratives. Well, she might have kicked him in the leg. She might have got it from his leg. He has jeans on. They didn't meet their burden with proof to respect beyond a reasonable doubt, ladies and gentlemen, of the mental elements. And they didn't meet it, ladies and gentlemen, because that's not proof that you rely upon in the most important of your own affairs. You would not lie on that prosecutor's office, ladies and gentlemen, to do a decision for an elderly parent or surgery with a client. You would want the DNA tested. That's what you do. You would give the full picture. Ladies and gentlemen, we believe your analysis would stop there, because they haven't met their burden of proof beyond a reasonable doubt for multiple reasons, between the mental elements for murder, felonious assault, and for manslaughter with provocation. Okay? Even if you do, though, we're here today because we don't believe with their side. But even if you do, what's the next step? You then go to the analysis number 2, whether or not we've met our burden. Proof more likely than not. Okay? 2 components. What's the first component we have to do? Number 1, is it more likely than not that Andy Mitchell had a subjective belief that an imminent fear of great bodily harm or death? And number 2, more likely than not, had an objective, reasonably, under the circumstances of officer at the scene, based on everything that happened, to make a decision to use deadly force. Not how to, not should, could have, would have done this. It's whether or not to make a decision to use a deadly force. That's the analysis, ladies and gentlemen. Because if you go from non-deadly force, the physical struggle, and to trying to get the thing, there has to be a determining factor of whether or not you're allowed to use deadly force. It's not how you use it. It's if you're allowed to use it. And in this case, ladies and gentlemen, we've proved both prongs more likely than not. How did we do that? More than 50%. How did we do that? First of all, Mr. Mitchell tells you what happened during the struggle. He tells you she resisted. You hear her resisting. He tells you that then he realizes he's cut. Okay? So first prong again. What's the first prong? Did we prove more likely than not that Andy Mitchell was in imminent fear of great bodily harm or serious or death? Okay? So that's the first thing we have to prove. All right? Well, Andy Mitchell walks you through what happened, walks you through being sliced, walks you through being choked, right? All those things. Okay? So, again, ladies and gentlemen, have we proven that? Of course we have proven it more likely than not. But don't just take our word for it. Okay? Don't just take our word for it. Let's analyze. Now, again, it's common sense. This is when you use your common sense. You use it the whole time. But, ladies and gentlemen, did he believe there was an imminent, soon-to-be threat? Of course he did, because there was already an actual injury. There was already an actual threat that occurred when he got stabbed or slaps. There's already an actual threat that occurred when he got choked. There's no eminence anymore, ladies and gentlemen. Now it's whether it's reasonable for him to believe that it might happen again. Okay? So that's the aspect, and it's in his mind. And whether what was in his mind was reasonable based on what was going on, based on the slashing, based on the choking. But don't just take our word for it, ladies and gentlemen. Let's look at what Mr. Patrick said about that, okay? Remember when I asked Mr. Patrick about, hey, talk to me about the cumulative effect of behavior. And he said, well, cumulative effect of behavior is if they continue resisting, continue fighting, they continue their actions. And I said, okay, and you testified about that previously under oath. He said, yes. Couldn't remember the case, so I showed him the case. And it had to do with a baseball bat, okay? And it had to do with the willingness to injure or the willingness to kill someone. And okay, and I had him read a quote to you. Which may I have? I might have the Elmo. I'm sorry. Okay, and I quote: "It's a judgment thing. What I'm saying is the cumulative effect of his behavior, his continuous fighting, his continuous resistance, his aggression. You know, the moment he hit Wagers in the head with the baseball bat, he established that he was willing and intending to kill that police officer." A willingness and intent to injure or kill a police officer, okay? And then I walked him through this situation. And I said, let's compare that to this situation. Was Donna Castleberry resisting? He said yes. Was Donna Castleberry, did she continue to resist? He said yes. Did she continue to fight? Yes. When she took the knife out and cut him, and was it reasonable for him to believe she was trying to seriously harm him? Yes. Was it reasonable for him to look for a continued attack? Yes. And when she continued the attack by choking him to the point of almost losing consciousness, was that reasonable for him to believe? Yes. Yes. He agreed, ladies and gentlemen. And I asked him, so based on that and his own testimony before, that once someone slices your hand, it doesn't matter why they do that. The officer has the belief at that point in time that it's reasonable, that they have the willingness and the commitment to injure or kill. That's based on their training, ladies and gentlemen. That's what their own experts said. Have we proven more likely than not that Andy Mitchell had a subjective belief of imminent serious physical injury or harm? Of course we did, because he received 2 actual threats occurred, as well as it's reasonable for him to believe that it's going to continue. We have proven that. Now, they go after Mr. Mitchell's credibility on the PowerPoints and his reasonableness. Let's look at that credibility, okay? Let's look at that. Let's examine that now. Let's do what we do in closing arguments. Let's wipe away the smoke. Let's get to the heart of the issue, okay? The issue is Andy Mitchell gives a written statement. He doesn't know anything about the evidence. He doesn't know there's a camera up there. He doesn't know anything. All he has is his memory. He's hoping that he turned the recorder on. He hasn't heard the recording, so he gives a statement. Okay, he does the best he can to give a statement. Then he goes in for an interview. He gives an interview. Then at the end of the interview, they play him the audio tape. What did you not remember? Geez, I didn't know the window was down, and I heard that the door was open. I didn't know the door was open. Okay? He's allowed to be mistaken when you're in a life and death situation. You're trying to recall that. Okay? But it's a false narrative. He's allowed to be mistaken. But he's been consistent, ladies and gentlemen. When he gave a written statement, when he gave an interview, and then when he testified at grand jury, he didn't know. He didn't know that they synced it up. Then he got to see the video. I'm mistaken that the door was open. I'm mistaken. So the issue, ladies and gentlemen, is whether or not, and this will be in your instructions, unlike the prosecutor's closing, this will be in there that an officer is allowed to be mistaken as long as that mistake is reasonable as to what was occurring and a recall of that. And you have information as to why they don't recall it. We all remember differently in life and death situations. The chemicals kick in, that fight or flight they talked about. The first 15 seconds, you're all amped up, and then you go down, okay? And both witnesses said, I would not expect them to remember everything that occurred. It's impossible, ladies and gentlemen. And you know it's impossible. And you know it's reasonable for those mistakes. That's why I gave you the example in voir dire, ladies and gentlemen, about the gorilla. I sat here and said, in a controlled environment, 70 degrees. I told you, your life depends on this. You have to watch how many times the people in the white t-shirt pass the ball to each other. Okay, now, picture this. A month later, I say, hey, I need a written statement about what happened. Everybody writes down what they believe they saw, right? What you believe you experienced. Some of you didn't see the gorilla. I bring you in for an interview, and I'm like, hey, you didn't see the gorilla. What do you mean gorilla? There was no gorilla. You didn't believe me last week. What do you mean gorilla? There was a gorilla in there, okay? And well, why? Does that mean you're lying? No. Does that mean you're a bad person, you don't have credibility? No, ladies and gentlemen. It means you were focused on something else and your brain didn't allow you to see it. Some people did, some people didn't. And when you were in a controlled environment, imagine trying to make that determination or something similar to that when you're in a life or death situation. That's why, ladies and gentlemen, but they want to attack that. His focus is on what? They kept saying, well, isn't to the experts, isn't the focus supposed to be on the knife? No. Aren't you supposed to shoot the knife? No, your focus is on survival. Your focus is on staying alive. That's how the body reacts. Let's talk about his credibility, ladies and gentlemen. Let's talk about that, okay? Ladies and gentlemen, Andy Mitchell didn't have the ability to spend 41 minutes examining each little 8-10 second stop of the audio and video. He didn't have that luxury. Why? Because they're not trained to. He's in a life or death, dynamic, fluid, non-static situation that's happening after he received a slash to his hand, that's happening after he choked. Of course he's not going to remember those things. But what does he tell you every single time? He sat down and talked every single time, okay? Why he made the decision to use force that could take someone's life. He's never fired his gun in 30 years of policing. But in this situation, he told you why, ladies and gentlemen. Because he believed there to be an imminent attack on him, and he believed that he had to use deadly force. What has he said in every single statement? So, written statement, gives an interview, testifies, other hearings. Consistent. He's been consistent the entire time. Didn't see the knife when he got cut. He was choked. The attack never stopped. He didn't see the knife, but he believes she still had it because he didn't see it. And that's reasonable for him to believe, ladies and gentlemen. She was attacking him while kicking him in the back seat, while flailing her arms. It's like she had the knife. Nobody knows when the knife got to the front seat. And to try to indicate otherwise is simply not credible, ladies and gentlemen. Again, ladies and gentlemen, not just the DNA being on there, that's corroboration. Let's go to the bigger point, okay? They put up a witness whose main job, Agent Durst, Special Agent Durst is now a supervisor, whose main job at the Attorney General's office is to investigate crime scenes, recreate shootings, try to recreate the events based on what? The physical evidence. And that's what we talked about in voir dire, the difference between perceptions, perspectives from witnesses versus the physical evidence, okay? So Agent Durst's job is to take all the physical evidence in this situation. I think it was 55 or 56 items. You'll have it back there. All the stuff in this situation. And what does he do? He compares it to Andy Mitchell's written statement and recorded statements. He compares them, okay? Talk about credibility, ladies and gentlemen. This is their witness from the Attorney General's office, David Yost. I have reviewed all materials provided me by the Columbus Division of Police, to include investigative reports, photographs, laboratory results, autopsy reports, statements, audio recordings, video recordings. I have found no discrepancies or conflicts between the items of physical evidence and the statement of Detective Mitchell regarding what occurred during this incident. I have found no conflicts. That's a seal of credibility from the Attorney General's office, ladies and gentlemen, from David Yost's office, dated July 23rd, 2019, and you'll have this back there. I have found no inconsistencies, no conflicts or discrepancies. That is a stamp, ladies and gentlemen, of credibility. That's the government saying, I listened to his statement, I read his statement, and I compared it to the 53 items that were there. And why does he reach that? What does Annie Mitchell say about the threat in the back? That she was a threat. She was kicking and moving, right? And she was a threat. Well, yeah. What do the flight paths show? One goes that way, to the left. One goes to the right. One goes to the center. Is that consistent with someone moving around trying to attack you? Yes, said Yuri Patrick. Yes, said Agent Durst. That's consistent with that. That's consistent with someone moving in the back. But yet they attacked his credibility and his reasonableness in that situation. But their own expert, ladies and gentlemen, their own expert contradicts that. And you'll have this back there. What's important, ladies and gentlemen, about also the physical evidence? What did both experts tell you? The closer the proximity, the more danger. The closer to that, right? So what do we know about the physical evidence? I talked about this, okay? In Mr. Patrick's report, he said, oh, Don Casper was sitting in the back seat, okay? Now, what do we know? I'll test it, not that flexible. What do we know about one of the wounds? It has stippling, okay? It came in here, down here, out the calf, and then somehow up into the thigh, okay? Somehow up into the thigh. And what did every single person tell you, ladies and gentlemen, that when we brought up the mention of stippling, okay? What did every single person? It has to happen from 0 to 18. 0 is here to 18 inches. That's 0 to 18. That's how far the gun had to be. Could have been closer, could have been here, could have been there, could have been here. Maybe it was 19, maybe it was 20. But the general premise is 0 to 18. So that means that that gun, wherever she was, had to be that close. 0 to 18, that's the most. From her chin, okay? Now, do we think that she was seated at the time she received that? Absolutely not, ladies and gentlemen. Why? Because it went straight through here and out the calf, okay? So it went right here. So it went straight through here and out the calf, okay? So if she was seated, it would go into the seat. There is no bullet entrance wound in the back seat down in that lower level. And in order to then go from here to here, the leg has to be bent. Look, it has to be bent. That's the only way that that wound can go in that way and cause stippling. Do we know when that occurred? Absolutely not. Could it have occurred when she was going by him right here and he's shooting like this? Sure. Could it have occurred at another time? Yes, because you can't tell the order of the shots. But we know the close proximity, ladies and gentlemen, because of the physical evidence. Not just because of what Mr. Mitchell says, but because the physical evidence matches it. And again, he doesn't know any of this physical evidence, ladies and gentlemen. He doesn't know any of it. He doesn't have it by the time he gave an interview, statement, testimony 2 or 3 times on the oath, okay? Does it matter what foot he was choked with? No. He told you when he testified here, and they tried to make a big deal of it, it was the left one. Well, gee, eventually, we get something that says it's on there. Well, of course, that's what he thinks, but does he remember that? No, because he didn't put it in his first statement. He didn't give it his memory. He said, I was choked with a leg. He didn't know what leg. Does it really matter? Ladies and gentlemen, close proximity, it's important here because what did their own experts say? What's the rules when you're dealing with someone you're confronting with a knife? When a suspect has a knife, what did Yuri Patrick tell you, ladies and gentlemen? He told you that if they're within 21 feet, the suspect with a knife always wins versus a holstered gun with an officer. The suspect with a knife always wins. This is never outside of an arm's length. Mr. Patrick, never outside. You've seen that car. You've seen the fight that it contained. You can see the survival in there, ladies and gentlemen. Cooperation is not a coincidence. Annie Mitchell, physical evidence matching his statement is not a coincidence. Annie Mitchell saying where the flight paths were and it's consistent, it's not a coincidence. Annie Mitchell saying he was choked and there's DNA on the bottom, it's not a coincidence, ladies and gentlemen. Because if you're telling the truth about what you believe, and even if you're mistaken about something, as long as it's reasonable, that's what he believed, ladies and gentlemen. We have proven more likely than not, definitely, ladies and gentlemen, that that Annie Mitchell had a subjective belief that he was going to receive imminent harm or serious physical injury. And we have proven that beyond a reasonable doubt, and their expert has also proven that for us, ladies and gentlemen. And at the time he lost consciousness, was about to lose consciousness, and that struggle. Ladies and gentlemen, does it matter if the struggle happened right here, or right there, or right there? No. The struggle and the choking either happened or it didn't. Okay, again, it's a false narrative. Well, there's no DNA up here or by the radio. She had a dress on, okay? Did the struggle happen? We know it did. Did he get slashed? We know it did. Did he get choked? We know it did, okay? Now, second prong. That's everything that we prove. More likely than not, ladies and gentlemen, I submit to you it's much higher. We've proven much higher than that. Second prong. Did we prove at the time that he let go of the hands to reach for his weapon because he thought he was going to lose consciousness? Was that reasonable based on the situation of another officer being there, experiencing everything he did? Not could have, should have, would have. None of that. Is it reasonable for another officer to believe that they're required to use, that they have to use deadly force? Yes. And we've proven that. How have we proven that, ladies and gentlemen? Each and every now, got to bring in the false narrative. They know that we've proven that, but what do they have to make this case about? What do they have to make the case about? Every one of the questions. They have to make the case about, they want you to focus on allegedly that Donna Castleberry did not believe he was a police officer. Every one of their witnesses who's in law enforcement testified that doesn't matter when you have a lawful arrest. Officer McDaniel. Okay, what did Officer McDaniel, what did Officer McDaniel tell you about? No, I've had lots of people. He's a bigger guy. I've had lots of people not think. I have had people think I wasn't a police officer. I'm in uniform. I've had people think I'm not a police officer. It doesn't matter. If you have the lawful elements, which we do here, everyone's agreed, and you have the lawful right to arrest someone, it doesn't matter if they believe you or not. Detective Laura Evans said the exact same thing to you. Many times they don't believe. It doesn't matter. You're allowed to put your hands on them. You're allowed to go into their space. This whole questioning about, well, you went over, cross-examination, Ms. Mitchell, you went over into her space. There's no space belonging to anybody when you resist arrest. She told him she was going to resist. She then resisted. She then fought. There's no legal space. It's not like you can say, oh, yeah, hey, I don't believe you're an officer. I'm going to stop here and wait. There's no requirement to wait. There's no requirement to do any of that, ladies and gentlemen. Sergeant Evans, again, it goes through the whole scenario, ladies and gentlemen. Their own expert, ladies and gentlemen. And this is important because remember in the first prong I told you subjective belief. So Andy Mitchell's beliefs that they matter. Okay, now in the second prong, with the analysis of what's relevant or not, there's two things that we can't use. Okay? But they continue to do it. What did I ask him about, and I'm sorry, I'm terrible at this word. I'm going to say, what did I ask him about non-relevant factors versus irrelevant factors, okay? And he said point blank, in the second prong analysis, officer subjective intent. In Graham, the court explicitly held the subjective factors, such as the officer's intent or motivation, are not relevant. Suspect subjective intent. The subjective intent is not relevant. Why? It requires very little mentation to be dangerous. Even a rattlesnake is dangerous, but does not possess the requisite mental capacity to be prosecuted to form the intent to kill. So, non-relevant factors. His subjective intent and her subjective intent. These are what the law says, ladies and gentlemen, in Graham v. Connor and State v. White. Now we're getting into the legal process. Okay, and there's things that guide you on that. Okay, so their own expert says, sorry, her subjective intent doesn't matter when you analyze the second prong of reasonableness. Nor does his, whether he was upset, mad, or anything like that. Okay, so again, that contradicts their theory of provocation. Bottom line, ladies and gentlemen, we would submit that she knew he was. Why? Gee, I don't know, using common sense. After Andy Mitchell shows her the ID, shows her the badges, shows her the paperwork and stuff like that, then says, you still don't think I'm a police officer? And you hear it, play it. I didn't say that. If someone tells you, if you ask someone, you still don't believe me? I didn't say that. That's common sense, ladies and gentlemen. Common sense. Does Andy Mitchell know she had a warrant? No, but he tells her. this arrogance thing, he says, I'm not going to take you in if you don't have a warrant. How's that being arrogant? He tells her, I'm going to cuff you for our own safety. How's that being arrogant? How does arrogance, find for me, ladies and gentlemen, you go back in the jury room where the word arrogant is in your jury instructions. She had a warrant. She had drugs on her. She had felony drugs in her purse. She had high levels of drugs in her system of fentanyl, cocaine, and a veterinary drug taken either 5 minutes before she was picked up. The longest it could have been was 3 hours later. Is it reasonable to believe, ladies and gentlemen, when you look at this from hindsight? Now, again, you're not supposed to, but let's say that somehow, if you look at it, is it reasonable for someone to believe her behavior of being non-compliant? But again, even if her beliefs did matter, and Yuri Patrick and Kevin Davis says they don't, you don't go into the subjective beliefs and intent when you are analyzing the prong of reasonableness. Let's just look at common sense. The bystander who came by, right? The bystander who came by. Hey, this guy's trying to kill. This guy's trying to kill me. Can you call the police? The bystander comes by. Andy Mitchell responds, I am the police. He takes his ID and he turns towards the back window and puts it up. What's that guy do? He dumpster comes back. Does he think that Andy Mitchell's the police officer? Of course he does. Because if he thought that there was something wrong, ladies and gentlemen, all he had to do was come over and open the back door. Just like Officer McDaniel did. Okay? Just like Officer McDaniel did. But ladies and gentlemen, the 911 call, did that person on there believe that Andy Mitchell was a police officer? Of course. She mentioned it 2 or 3 times. You got a police officer who's hurt badly. So using just your common sense, but again, I don't even want to get it credit because it's not relevant. It's not relevant, ladies and gentlemen. Her subjective intent is not relevant. Her beliefs are not relevant at that point in time. What the law says, ladies and gentlemen, and what the law tells you in those jury instructions is you have to look at it from the eyes of a reasonable police officer on the scene, standing in Andy Mitchell's shoes, not Donna Castleberry's perspective. And that's humanly difficult to do. Every one of us, when we hear her losing her life, we know that a family here has lost a loved one. We know that, and the sympathy for there, okay? We all feel that way, jeez. But that's not what the law requires. The law requires to examine whether or not he's allowed to use deadly force after he is slashed, after he is choked, when he believes he's going to lose consciousness. That's what the analysis is, ladies and gentlemen. I told you before here that it's hard because you're human beings, you're going to have sympathy, okay? Why did they call Officer McDaniel? Not to give the testimony that Ms. Stevens brought out, not to give that. They put Officer McDaniel on there because he was the guy with the body camera focused on a non-moving Donna Castleberry for 8 minutes and 35 seconds. Did they put Officer Carter on, who was at the scene, with regards to the first person there and what his interactions with Andy Mitchell and what he? No, because they want to do that. They want to play that videotape over and over and over and over again in the audio tape because it's humanly tough. It's hard. You want to believe, ladies and gentlemen, that Andy Mitchell heard those words, and there's not one shred of evidence that he did, and I'll get to that. But what the law says, ladies and gentlemen, is the law tells you have to look at it from the eyes of a reasonable police officer, not from Donna Castleberry's perspective. Why, ladies and gentlemen? Why does the law tell us this? The law tells us this because they're trained. What are they trained about? Actions versus reactions. Actions versus reactions, right? So let's analyze this. An action is always faster than a reaction. Everyone's told you that. Let's look at it. Donna Castleberry's actions and Andy Mitchell's reactions. Her action, resisting arrest. She's resisting. He has to react. How does he react? He goes to cuff her. Her reaction, continuing to resist and taking out a knife and slashing his hand. Okay? At that point in time, their expert already has told you, ladies and gentlemen, if he saw the knife before, he'd be justified. If he shot right then, he'd be justified. Or right after, he'd be justified. Okay? So her action of taking the knife out and slicing him, what's his reaction? He tries to hold the hands. He's trying to get the knife out of there. He doesn't decide to shoot because he's not provoked or anything. He's trying to get the hands so he doesn't get stabbed again and slashed again. Okay? Her actions bring out the knife. The deceptiveness of it. That he asked her, do you have any weapons on you? She doesn't answer the question. So, ladies and gentlemen, her action of then him rolling the knife, what's her next action? Her action is putting the foot under his neck. What's his reaction? I'm about to lose consciousness. At that point in time, he makes the decision, all I have left to live is to reach for my weapon. If I let go of her hands, it's more of a risk. Both experts says that. As she gets close to him, it's more of a risk. Okay? Ladies and gentlemen, action, reaction. Just like Mr. Patrick said, a willingness to commit. Once she sliced him, that shows a willingness to commit, and it's reasonable for the police officer to believe that, ladies and gentlemen. Now, the government tries to argue that somehow, after this point, when he lets go, and she's a threat here, 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 and she's a threat behind, everybody told you that she's a threat from behind. Okay? So in that situation, ladies and gentlemen, then Mr. Cable asked Sergeant Evans, well, don't you want to make sure you can identify your target and you can shoot right at the target? You see that? You wouldn't shoot at someone if you couldn't see him. Well, guess what? He's stuck with Sergeant Evans' answer. Because Sergeant Evans, based on his training, knows. Mr. Cable doesn't have that training. Sergeant Evans says, I can think of 3 or 4 situations where that would be appropriate. That would be appropriate. That's just answering a question like that. Because that's what they're trained to do. So there are situations in which you shoot when you can't see. And they're stuck with that answer. But Miss Pritchard still got up here and said, well, he shot, he's not a reasonable officer, or he didn't reassess because he didn't see the target first. You had someone who's been trained and been in the thing for 34 years who says there's situations where you don't have to. Did anyone come in here and tell you that you can't shoot at someone if they go by your side or if you can't see them? No. Because it's a false premise, ladies and gentlemen. What else, ladies and gentlemen, doesn't fit their case, their theory of the case? Let's just for their sake, let's do actions versus words, okay? Are officers trained to react to words? Words are used to react. No. How do we know that? Because if they was, Sergeant Gagnon or Officer Gagnon would have told you that on the targets that they use, they'd have audio. Hey, yeah, don't shoot, I'm just going here. They'd have audio. They'd be trained on what the target said or what the potential suspect said. They don't train like that because they can't take that in consideration. Because if you stop to think about what the person said or what the person's intent was, you're dead. So they train on actions, ladies and gentlemen, or else you would have talking mannequins and stuff. Hey, no, I know that's a gun, but it's unloaded. Don't shoot. They're not trained that way. It's a false premise, ladies and gentlemen, for them to put something else forward. The car, ladies and gentlemen, again, sympathy, empathy. Every witness testified that it's not just more likely than not, probably most likely than not, that he didn't hear it. He told you he didn't hear it, the words, once the first shot went off. That's when you hear that. Sorry, when the first shot off. Officer Gagnon told you that he's been trained inside a car with 2 types of ear protection, and when the shot went off, it went through his body and he heard nothing. He had ringing. He had ringing in his ears. Take away that in a small space. The range has padded areas. You have those things and it's still loud. Put yourself in a car and a gun goes off and the reverberations. Who else confirmed that? Their own agent, Agent Loomis. I said, Agent Loomis, you're not testifying that you heard that. No. The device picked it up because the device has a different structure than the human ear. The human ear, he says, has trauma to it. Okay? So, ladies and gentlemen, a false premise, a narrative is that Annie Mitchell heard him. He told you he didn't, and every single law enforcement officer from the Columbus Police Department told you you're not hearing that. Their own experts said, no, most likely he didn't hear that. Not more likely than not, most likely he didn't. So did Officer Davis, but they have to continue to push play to try to do that for you. In fact, they put on an expert, ladies and gentlemen, who's never been a police officer. Hey, good guy. He's never been a police officer, all right? He was an FBI agent and something else, never been a police officer, okay? What did I ask him when he said, well, have you ever made an arrest on with prostitution or anything like that? And he said, I don't deal in that world. That's not my world. That's their case, ladies and gentlemen. Now, what are they supposed to do? What will you find in those jury instructions, ladies and gentlemen? You'll find the Graham and the White factors. You'll find the Graham and the White factors. Tell me in your recall when you're back there, how many times, what Graham and White factors did Mr. Patrick put in his analysis? What Graham and White factors? Now, listen, They're in your jury instructions for a reason, because those what are helping you to determine whether or not he acted reasonably when he decided to use deadly force. So is it, you are to analyze each of these factors. Is it an exhaustive list? No. But these are the factors that our Supreme Court, the number one case in Ohio, said when you're in Ohio and you're judging whether or not a police officer was reasonable, you use these factors. That's why they're in your jury instructions. Factor number one, severity of the crime at issue, right? Well, Mr. Patrick's trying to say it's prostitution. Okay. At first, you're investigating and arresting somebody for prostitution. But once she commits the felonious assault on him, once she slices him, the severity of the crime at issue is now a felonious assault, an attempted murder on a police officer's life. That's what it is. So have we proven that more likely than not? Yes, ladies and gentlemen, absolutely. Factor number two, whether the suspect poses an imminent threat of safety to the officer. This isn't an imminent threat, ladies and gentlemen, okay? This isn't an imminent threat. This is an actual threat because she cut him and she choked him, okay? That's the actual threat. So did Donna Casaberry pose a threat to him? Is it more likely than not that she did? That's your analysis. Yes, ladies and gentlemen. Whether the suspect actively resisting arrest. Everybody's told you that. All experts. She told you that. I'm not going to go in cuffs. She resists. So is it more likely than not that that factor we proved to you? Absolutely. The suspect's demeanor. Now, Ms. Pritchard in her thing on there said she was, I think, suspicious but polite or something like that, or cautious but suspicious. Demeanor means, ladies and gentlemen, what were her actions? Was she resisting? Was she saying no? Was she resisting arrest? Was she fighting? Was she aggressive? Was she the person who took it to the next level every single time? Was she the person that brought the knife into the equation? Yes, that's what demeanor is, ladies and gentlemen. And we've proven more likely than not that factor. Whether the suspect was intoxicated and non-compliant. That's in there together, ladies and gentlemen. Was she non-compliant? Yes. Mr. Patrick agreed to that each and every step. So did Mr. Davis. They put intoxication in there because they're trying to say sometimes people who are high on drugs or intoxicated are more non-compliant than others. You have to take that into your consideration, okay, when you're weighing that factor. Whether the suspect appears to be violent or dangerous. Have we proven that more likely than not? Absolutely, ladies and gentlemen. She was violent. She slashed him. She was dangerous. She had a dangerous weapon on her, and she pulled it out. Even if she didn't cut him, if she just pulled it out and said, I have a knife, okay, we've proven that she was dangerous. The duration of the confrontation, it could be 47 seconds, it could be 8 minutes. The duration of it, have we proven that this wasn't just a quick judgment by Mr. Mitchell to use lethal force? No. You have a long duration of this situation. You're to analyze that. Whether it occurred during a chase or arrest. Yes, it occurred during an arrest. Yes, she resisted. Okay? That's an either or. So did it occur during a chase? There's no chase. Did it occur during arrest? Yes. We have proven that factor more likely than not. We've proven that 100%. Most of these we've proven 100%. The possibility that the suspect may be armed. It's not a possibility. It's an actual fact. She was armed, ladies and gentlemen. And she made that choice to bring the knife out. The size and stature of the parties. Absolutely. He's bigger than her. Sometimes men are stronger than women. Yeah. I don't want to say that because Ms. Stevens will yell at me if I say that all men are stronger, physically stronger than women. So, ladies and gentlemen, but what did you hear about the great equalizer? The great equalizer is if you have a weapon, and it doesn't take any skill to use a knife. You have to be trained how to shoot a gun. Okay? So, again, the last one, the only one that even goes favor the number of suspects. Okay? The greater number of suspects against an individual officer, you could see that would be, more risky. Okay? There's only one suspect here. So out of the 11 factors, okay, that Graham and White lay out, we have proven all of those more likely than not, ladies and gentlemen. Did Yuri Patrick go through that analysis on direct examination with Ms. Pritchard? No. Did they talk about that in their opening? No, ladies and gentlemen. I had to bring that out. I had to bring it out. We have proven it was more likely than reasonable and more likely than not that when Andy Mitchell used deadly force, ladies and gentlemen, you take into account the totality of the situation based on eyes of a reasonable police officer in his eyes, his shoes, and his experience. We have proven both prong one, the subjective belief of an eminent threat, and that he was reasonable to make the decision to use deadly force against him. We have proven that way beyond more likely than not. And you know who else did? The government did for us, ladies and gentlemen. And they did for us by their own expert. May I have the video, please? I have a moment, Your Honor. Sorry.
Yes. I'm just wondering where that is.
Is it fair to say that that entire encounter, that the two parties were never outside of the arm's length? Could you pause that again, just to turn the volume? And again, ladies and gentlemen, this is their expert proving both prongs of our burden, prong one and prong two. Is it fair to say that that entire encounter, that the two parties were never outside of an arm's length away from one another?
Yes.
Okay. Well, and the closer the proximity is to somebody, the more dangerous the suspect is to the officer, correct?
Yes.
Now, you're aware after reviewing my client's written statement and testimonies that my client believed that when he let go of her arms, that she still had the knife, correct?
Yes.
Okay. And that's a reasonable thing to believe, correct?
Yes.
Okay. And then, as indicated, Ms. Castleberry came towards him to get in next to him, correct?
Yes.
So if my client had a reasonable belief that she still had the knife when she was in the back seat, it's reasonably for him to perceive another imminent threat, correct?
Yes.
Stunned. Stunned, ladies and gentlemen. Their own expert just said that he had a reasonable belief in a threat, and he was reasonable to believe she had the knife in the back and was still a deadly threat. Carla, could you read back that for me, please? That's what they're trained to do, right? To perceive that's reasonable for them to believe that, correct?
They are trained to recognize circumstances and suspects and what they do and respond accordingly, yes.
That's their witness, ladies and gentlemen. That's proof, more likely than not, of both prong one, a reasonable belief of an imminent threat, and prong two, reasonable to use deadly force in that situation, ladies and gentlemen. That's not our words. That's his words. Now, you saw a look on his face. You saw when he answered, he had done yes. He had to be credible there. He had to be credible because he's stuck with that and he knows what the answer is. And he knows I know what the answer is. And he has to say, yes, she's a threat to him back there. And yes, they have to react to that situation. And that's what Mr. Mitchell did, ladies and gentlemen. The government didn't meet its burden, ladies and gentlemen. You would not rely upon the prosecutors in this case to make a decision for an elderly parent or surgery for a child. You would want them, ladies and gentlemen, to see if there's corroboration with the DNA. You would want to know the truth about policies and procedures and what's required and what's not. You would want an analysis of reasonable factors that we gave you. You would want to know that an officer can be mistaken. Nothing said in his report or their direct or anything about an officer being mistaken. Nothing. You would want to know what their expert believed. And what he just told you, was it reasonable to believe that Donna Castleberry had a knife when she was coming towards him to get to the back seat, and it was reasonable for him to perceive that it was an imminent threat, a threat at the time, and adjust, and therefore to use deadly force. That's the decision. He agreed. He agreed it was okay to shoot before the knife caused injury. He agreed that it would be to shoot right after, ladies and gentlemen. It was okay. And it's reasonable for him to use deadly force when he believed that she still had the knife. The answer was yes, ladies and gentlemen. The reality is you would not rely on the information that they've proven their case beyond a reasonable doubt. And we have definitely proved to you prong one of his subjective belief, and prong two, that he reacted reasonably when he made the decision to use deadly force. There is only one verdict in this case, ladies and gentlemen. There is only one verdict, and that my client is not guilty of both counts because he was justified in saving his life on that day. I thank you for your time. I wish you Godspeed and good luck. Thank you, ladies and gentlemen.
Harley, you doing all right? Everyone else doing all right? Yeah. You want to put white noise on?
All rise.
Everyone can have a seat. Is there any rebuttal closing?
Folks, good morning. Richard, Judge, Carla,
Formally, Courtney.
and formerly Courtney. Good morning. This is the part where I rebut what Mr. Collins has said to you, and I don't have time, and I don't think you have the energy to go through everything piece by piece. But I want to start out with a couple things. Mr. Collins put on Uri Patrick's testimony along with the transcript just 15 minutes ago. And it started with this part of the transcript. And the question and the whole basis was based on this question. So if my client had a reasonable belief, so now he's having Uri boxed into if you accept that, and you don't have to, and Uri doesn't have to. But he's answering the question. If you had a reasonable belief that the knife, that she still had the knife when she went in the back seat, then, if he believes that, then it's reasonable. Folks, the knife was out of the equation before she got to the back seat. He testifies that the cuts came in the front. There is absolutely no further evidence of an injury. There's no further evidence of a cut in the car. There is no further evidence that you would expect to see if somebody's waving that knife around causing problems. The knife was out of the equation early. But he still says, under that hypothetical, Mr. Uri Patrick, would it be reasonable? Which, of course, he would say yes, under those circumstances. But that's not the circumstances. And then Mr. Collins says, gets the answer he wants. They're trained to recognize circumstances and suspects and what they do. And the red line I have drawn there is where Mr. Collins stopped showing you this transcript. And it's where he stopped talking about everything. And it's why the false perceptions, why the things that he said were only half of an explanation. Because if you keep reading one more question, the answer to the very next question from Uri Patrick is, and then things change. Because Uri Patrick knows that the hypothetical he's just been talked into isn't what happened. And it doesn't carry the day. And then things changed. You heard Uri Patrick's testimony. The other thing Mr. Collins did was put on that same screen, I don't need this anymore, Courtney, thank you. Special Agent Durst's first paragraph of that cover letter that says he found nothing inconsistent in the evidence in what Mr. Mitchell said. And then Mr. Collins stops. I guess as either hoping or not believing you'll remember Special Agent Durst's live testimony when I asked him about that very paragraph. And the rest of that truth is, not just what Mr. Collins showed you, the rest of that truth is that Special Agent Durst said, none of this means it was reasonable. I'm making no comment whatsoever on whether this was a reasonable act or not. That's not my place. I can tell you he said he shot 6 times, I found 6 bullets. That's the rest of that. So it's one thing for me to point these things out, but ask yourself, follow this through intellectually, honestly. Why are you only being shown parts of these transcripts? Why are you only being presented with a written statement and not reminded of the live testimony? It's because these things hurt. Because the truth hurts in this case. He mentioned we could have called Brian Carter to the stand, the canine officer. He's right, but guess who else could have? He knew that when he told you that. The witnesses were called because of the people that were there. He makes a big point of our witnesses versus their witnesses. And to some degree, I guess, because we called them, you can call them our witnesses. But everybody's CPD here. They're all friends with Andrew Mitchell. They're called because they're the people that have the information. And none of them went as far as to say they thought this was reasonable because they don't know. They're not in the car. I won't lie for them. Ask yourself why you're only being told part of the story. He makes a lot about the DNA. You'll look at the DNA. You've got it all. The DNA from the shoe was submitted at the same time everything else was. Detective Shepard said that he had a conversation with some prior prosecutors who at some point apparently told him it wasn't necessary. But he did it anyway. Well, there's a lot of reasons, and we talked about why it may or may not be necessary, and he wants to make a big fact that this was somehow obscuring justice. The single most important part of this evidence, of this trial, is that sync audio and videotape. And that was requested by our office, not by Shepard. And I'll tell you why this DNA is not as much as you might think it is. His DNA is on the bottom of her left foot. It could be that she put her foot to his throat. By the way, you won't see that. Watch this video closely. You don't ever see his head back pinned up against his driver's seat. You don't see her in the middle console. You don't see any damage for the rearview mirror. You don't see anything other than him going across to her until she bolts. Watch the video and tell if it matches up with his version. So the idea that he was choked at all is coming straight from his mouth. So that DNA could be indicative of that. It could be that he touched her on her way back. It could be that it's his car and she could get it anywhere. And I'll give you an example. When you look at this DNA, what you're going to find is that her DNA is not on the handcuffs. We know she touched him. He said she chucked him out the window. We didn't find DNA on her handcuffs. Her DNA is on the gun. His DNA is on her bag. In a small enclosed like this, space like this, DNA is everywhere. This is not the silver bullet he wants it to be. And it's not obstruction. We have proven beyond a reasonable doubt the elements of the offense. Did he, when a person pulls a trigger and shoots somebody multiple times, they know that that's going to cause serious physical harm. And if that leads to death, it's murder. It's that simple. He killed Donna Castro. Voluntary manslaughter is a different charge, and it's not an issue of not believing one or the other. It's an issue of this is what the evidence is. You hear him get angry. Is he provoked? And that is exclusively your determination, not a theory on whether the state believes one or the other. You got the evidence you got because that's the evidence. And you're asked to apply the law accordingly. And the law goes in a couple different directions, including justification. And he's right. If you find there was justification to this, it ends everything. But if not, then you have further work to do on which way to go with it. And that's simply the law, not a personal choice. Donna Castleberry's last moments on earth were not trying to cut Andrew Mitchell because she was afraid of a warrant. You heard her statements. Mr. Collins goes on to great extent about what you can and cannot listen to, what applies, what intent is, and the jury instructions tell you to consider and compare all evidence. That includes the videotape, the words on the videotape, the DNA, all of it. He put up a list of things picked from a case as if it were an exclusive list, and it's not. Graham versus Connor says that in evaluating reasonableness in threat perception cases, and this is in your jury, I'm reading the jury instructions, the considerations may include but are not limited to, and then list several things, including glances. And he's right, those things up there are on there, but so are things that the officers testified to in their training. The ability to create distance and time. The list that he put up there is not an exclusive list, because you can't put on any single case the myriad of things that could happen in a police encounter with a civilian. Like that's what happened here. So you can consider, in deciding whether or not he took reasonable objective actions, everything that was going on. Is she a threat? She has to be a threat. In order for him to be reasonable, she has to be a threat. That's why they don't want you to consider things she says. You can review those objectively. Our experts reviewed those objectively. Uri Patrick is, by the definition of their expert, the giant upon whose shoulders he stands. Uri Patrick testified in the White case that they keep talking about. I think it's reasonable that Uri Patrick knows how to apply the Graham factors. And if you cherry pick some out and make him say, well, you don't have that here, it doesn't mean he misapplied the Graham. The man knows how to apply the Graham factors. And things changed. And that's where they want to stop. They want to stop this at her cutting him. But things changed, and you have to reassess. Every single person who was asked directly that question on the stand, whether they were put up by us or put up by the defense, said, yes, you have a duty to reassess. He talked about Sergeant Evans' testimony. The other thing we're stuck with is Evans says, yeah, you can reassess. You shoot, you get a second, maybe a half second to reassess. By his count, Andy Mitchell could have reassessed 40 times from the time he was cut. And yet, what did he say on the stand? I decided to shoot her right then. That's not reassessing. Uri Patrick says that that's not reassessing. Not 100% sure what Kevin Davis told you. At least in response to Ms. Pritchard, I don't think the man could give a straight answer if he was talking about a straight line. But they all agree you have to reassess. And things changed. And so you're supposed to take this encounter from an ordinary, reasonable, prudent police officer's standpoint. Did he subjectively say that he was in fear for his life? Of course he did. You'd expect the officer to say, after he has just killed somebody, that I was in fear for my life. So you move to the objective. And you don't get to have a jury ignore evidence because you don't remember it or because you say you don't remember it. That's not how this works. You don't go, oh, he doesn't remember that, so we can't take that into consideration. That is not how this works. It's what an ordinary, reasonable, prudent police officer in his position would see and do. And Mr. Mitchell doesn't remember a lot of things that are very, very damaging to him. That's not a coincidence. He remembered very straightforward that it was the left foot until Miss Pritchard pushed him. Under oath, it was the left foot. And then he admitted he only said that because he knew the DNA was on the left shoe. He didn't know what foot it was on. He's crafting his responses as evidence is presented to him because he knows he's in trouble. An ordinary, reasonable, prudent police officer would take into consideration what the suspect's demeanor is and what they're doing. Donna Castleberry was trying to escape a rapist. That's what she was doing. Was she wrong about that? Yes. But she was trying to escape a rapist. That's what she was doing. And he has to recognize this. They're trained to be better. Every one of the folks on the stand said that. They are trained to be better at this. We're allowed to expect better. An ordinary, reasonable police officer takes into account her demeanor. An ordinary, reasonable police officer knows when they pull a handle to a door that the door opens. An ordinary, reasonable, prudent police officer knows when their foot hits the ground that they're out, or can be. Ordinary, reasonable, prudent police officer knows that when that happens, you have created, this is not coulda, woulda, shoulda, you have created time and distance. That's what an ordinary, reasonable, prudent police officer in that situation knows. And he ignores it. He ignores it because he's already made the decision. And when he turns back around, things have changed. And he ignores it. He was going to shoot her from the very beginning. There was nothing she could have done. Nothing. An ordinary, reasonable, prudent police officer reassesses as situations change. And he had plenty of time to do that, and he did not. Did Donna Castleberry cut him? Yeah, absolutely. Or he was cut while grabbing for the knife, but nobody disputes it's her knife. When cats are cornered, they do aggressive things. If you get a cat in the corner, when they see no other way out, they're going to hack. And it's not because they're trying to hurt, or it's not because they're the aggressor. It's because they want out. They're scared. That's what the confrontation with Donna Castleberry was. She wasn't a violent female aggressor with a deadly weapon. There is nothing that you will see on that video or hear that belies that. None of it. She's trying to get away, and she's lashing out any way she can because she's scared. But there's an important thing here. Donna Castleberry is not a cat. Donna Castleberry was a young woman. You saw her picture. She was a young woman that was in a very bad spot. She was a young woman in a position where she had no power. Donna Castleberry had no power, no authority, and was in a position that any of us would never want to see our mothers, our sisters, or our daughters be in. And that's where she found herself that August morning in 2018. She deserved respect from law enforcement at that time. She deserved respect and maybe a little bit of patience. once an objective person sees what's going on. Respect and a little bit of patience is what she deserved. She did not deserve to be gunned down in fear, trapped in the back of a crappy undercover police car by Andrew Mitchell. I appreciate your time, appreciate your efforts, your patience, and God bless you in your deliberations. Judge, thank you.
Ladies and gentlemen, if you could turn to page 13 if you want to continue reading. Your initial conduct upon entering the jury room is important. It is not wise immediately to express a determination to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you later decide you are wrong. Consult with one another, consider each other's views, and deliberate with the objective of reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide the case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender honest convictions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. Before you can find the defendant guilty, you must unanimously agree on your verdict. On behalf of the public and the parties, the court expresses appreciation for your services in performing this important public function. After your verdict is returned, you may discuss this case with anyone, but you are not required to do so. Whether you discuss the case with counsel or anyone else after you are discharged is a matter of your own free choice. When you retire to the jury room, you should select a foreperson. The foreperson will be responsible for the exhibits in the verdict forms and return them to the courtroom. The foreperson will see that your discussions are orderly and that each juror has the opportunity to discuss the case and to cast his or her vote. Otherwise, the authority of the foreperson is the same as any other juror. Until your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdict. If you have a question, write them on a piece of paper and give the paper to the bailiff. When all 12 of you agree on a verdict, all of you should sign the appropriate verdict form in ink and advise the bailiff by turning on the green light. You will then be returned to the courtroom. Alternate jurors were selected to serve in the event of any misfortune befalling a member of the panel. Each of you will remain as an alternate members of this panel until your jury has reached a verdict. If your service is needed, you will be in panel with the other regular jurors, and deliberations will start anew. You may return to the general jury room to await further instructions from the court. Since you are still an alternate juror, you are not to discuss this case with anyone, and you're not to tell anyone how you would vote on this case. Also, we, the jury, upon our oaths and law and evidence in this case, find the defendant not guilty of voluntary manslaughter as charged in count 2 of the indictment, signed this 18th day of April 2023 by each and every juror. Do you guys want the jury pooled?
No.
All right, ladies and gentlemen, thank you. On behalf of the community, on behalf of the court, and on behalf of the parties, thank you so much for being responsible citizens and coming down here. You are now discharged from all admonitions and instructions. Thank you again. All right. Have a seat. Mr. Mitchell, you're hereby discharged from this case.